Hello, my name is Emma Snape, Special Event and Program Manager for the Maltz Museum of Jewish Heritage. On behalf of everyone at the museum, welcome to our virtual program, I Dissent, Discussion on Reproductive Rights. This program is inspired by our newest special exhibition, Notorious RBG, The Life and Times of Ruth Bader Ginsburg, presented locally by PNC Bank. I'd like to thank PNC and all of our sponsors and partners, including today's programming partner, the Cleveland Metropolitan Bar Association, who make it possible for us to bring a first-of-its-kind exhibition like this one to Cleveland. The exhibition is open now, and we're welcoming visitors to join us safely in person, Wednesday through Sunday from 10 a.m. to 5 p.m. at the museum. We're using best practice protocols such as contactless time ticketing, wearing masks, and maintaining social distancing to ensure a safe visiting experience. And of course, we also welcome you to explore the Notorious RBG from the comfort of home. On the first and third Tuesday of the month at 2 p.m., we offer a virtual online tour of the exhibit, or you can bring a group for a private online experience. Whichever way you would like to visit the collection, you can find out more through our website, www.maltzmuseum.org. Before we get started, for a brief bit of housekeeping, if you are registered for today's program through the Cleveland Metropolitan Bar Association for CLE credit, please be sure to view the program on your phone or computer rather than just calling in with your phone and listening to audio. And to complete the brief survey, I will send you after the program. Whether you're here for CLE credit today or not, I'd like to thank you for joining us for the third program in our I Dissent series of programs, in which women in Cleveland's legal community discuss some of the late Justice Ginsburg's most notorious dissents. In today's program, Laura Hauser and Karen Rubin will dig into the subject of reproductive rights, looking at some of Ruth Bader Ginsburg's dissents on the subject. Laura Hauser spent 25 years in private practice and large Ohio firms before going in-house as the general counsel of a public company. And in 2015, she opened the doors of her own firm, Hauser Law, LLC. Her practice focuses on business disputes and litigation, including in construction, real estate, and employment rights and obligations. Laura's practice includes the representation of a wide range of businesses, industries, and technologies, including general contractors, architects, engineers, real estate developers, financial institutions, manufacturers, startup ventures, C-suite executive, law firms, and individuals in their business and employment matters. Karen Rubin is the counsel at Thompson Hine and a member of the firm's business litigation practice group, focusing her work on a wide variety of litigation issues. Karen practices, teaches, and writes in the area of professional responsibility, including malpractice and legal ethics. She is the chair of the Cleveland Metropolitan Bar Association's Ethics Committee and was appointed in 2020 to a 3-year term on the Ohio Supreme Court's Commission on Professionalism. She also served on the court's task force on the disciplinary system, charged with recommending ways to improve and promote trust in the attorney discipline process. She's also a member and past chair of the Ohio State Bar Association's Ethics Committee and has authored several ethics opinions on behalf of OSBA, interpreting the Ohio Rules of Professional Conduct. And now, without any further ado, please join me in welcoming Karen and Laura to the virtual stage. Thank you both.
Thank you so very much. Very, very happy to be here. Honored to be one of the presenters. Why don't we get our slideshow going? Great. Thanks very, very much. So as Emma suggested, let's have the first slide, Will. Justice Ruth Bader Ginsburg was known for her women's health and reproductive rights advocacy. And that really went back way longer than way before she was the notorious RBG. It actually dated back to her co-founding of the Women's Rights Project at the ACLU back in 1972, and her longtime service as the project's general counsel. One of her early cases in the women's health arena came back in 1973, which was the same year that Roe v. Wade was decided. And that year, as an advocate, Ginsburg took on the North Carolina Eugenics Board in a case challenging involuntary sterilization under a North Carolina statute. Her client, a teenage mother. The case I'm going to talk about today, Gonzales v. Carhart, was decided 40 years later with the former advocate now on the High Court. It was decided in 2007, and it provided the occasion for one of RBG's great dissents. Before we dig into the dissent itself, let's look at the background of the case and set it in some context. So the state of Nebraska, back in the late 90s, had enacted a ban on so-called partial birth abortion, which is a term not recognized or used by doctors. In 2000, the Supreme Court struck down the statute as unconstitutional under Roe v. Wade, partly because the Nebraska statute had no exception, even if the health of the mother was in danger. And the opinion in that case, on that Nebraska statute, came down 5-4, with the majority including both Justice Ginsburg and Justice Sandra Day O'Connor. It also included Justices Breyer, the late Justice Stevens, and Justice Souter. 3 years later, in response to the ruling, Congress passed the Partial Birth Abortion Ban Act of 2003. This is a very striking picture of President Bush signing that act into law. The act banned and criminalized a particular procedure used to carry out second trimester abortion. The procedure was known as intact dilation and extraction, or intact D&E. In drafting that act, Congress tried to dodge and step around the pitfall of trying to regulate abortions before the time that a fetus becomes viable. That had been one of the constitutional infirmities found in the Nebraska statute. So Congress was going to try to dodge around that and still ban intact D&E. But like the Nebraska statute, the congressional ban had no exception that would allow intact D&E if it were necessary in order to protect a woman's health. So as a practical matter, the act was really indistinguishable from the Nebraska statute that the court had already rejected. But in passing the 2003 ban on intact D&E, however, Congress claimed that there was a moral and medical consensus that the procedure was gruesome, that it was inhumane, and that it was never medically necessary. In reality, the record that was developed in congressional hearings on the act, those hearings themselves showed that there really was no such consensus at all. So 2 different court challenges resulted from the act. One was by abortion doctors, and one was by abortion advocacy groups. And these challenges made their way from the federal district courts up to 2 different courts of appeals for the 8th Circuit and for the 9th Circuit. And eventually they were consolidated for decision in the US Supreme Court. In 2007, reversing the lower courts, the Supreme Court issued its 5-4 decision. It upheld the act, including its ban on intact D&E. And for the first time, the court let stand an abortion statute that made no exception for the health of the mother. By the way, Dr. Leroy Carhart is still living. He's an Omaha doctor. He became known for performing abortions late in pregnancy and famous for his participation as the named plaintiff in the 2 Supreme Court cases that bear his name. So, who were the 5 justices who voted in the majority in the Carhart decision? They included Justice Anthony Kennedy. He was the author of the majority opinion. Chief Justice John Roberts, for some reason I don't have him pictured here. And the most junior justice on the court, then the most junior justice, Justice Samuel Alito. And Justice Alito was sitting on the court and in a position to cast that fifth vote because he had replaced Justice Sandra Day O'Connor, the FWOTSC, the first woman on the Supreme Court. Justice O'Connor had announced her retirement very suddenly in June 2005, when her husband, who was a brilliant lawyer in his own right, was becoming increasingly disabled by Alzheimer's disease. And then when John Roberts was in the very process of being confirmed to replace Justice O'Connor, William Rehnquist, the Chief Justice, died. And that gave then President Bush an additional pick for the Supreme Court. And he selected Alito. Alito, of course, was a staunch conservative, and he was later confirmed. So the 4 conservatives on the court thus became a majority of 5. But if O'Connor had delayed her resignation, really the announcement of her resignation, only a couple more months, she could have remained on the court realistically for another term. And Carhart could have possibly come out 5-4 the other way. And history might have been a little different. Justice O'Connor, very interesting. She was a Reagan appointee. Some have called her lukewarm on the issue of abortion rights, but others have noted that really she was at the ideological center of a court that was then, as now, extremely divided. And she actually was a key backer of abortion rights. She'd also, like Justice Ginsburg, had a long history of being concerned with the health, safety, and autonomy of women. And that really dated back to O'Connor's days as a state judge and an Arizona assistant attorney general. She had seen many abusive husbands come through the legal system. And I don't think it's too far a stretch to say that she had formative experiences that helped shape her jurisprudence. She was actually a vote for abortion rights in some important cases. Her jurisprudence really emphasized the limits on state power, that states were not and should not be in the position of imposing an undue burden, is how she put it, on the ability to exercise the right to abortion that Roe v. Wade had enshrined in the federal jurisprudence. If she'd been on the court in 2007, it's likely that she would have been the 5th vote to strike down the congressional ban on intact D&E. As it was, Carhart was a defeat. It was really a defeat in the area of reproductive rights. And it was the occasion for this strong and famous RBG dissent, which she authored. And she was joined by the 3 other liberal justices, Justice Souter, Justice Breyer, and the late Justice Stevens. Justice Breyer has been in the news very recently because of his age. Many commentators, progressive commentators, are urging Justice Breyer to retire in order to ensure that his replacement can be by President Biden while there is a Democratic majority holding in the Senate. So let's turn now, against all this context and background, let's turn to the dissent in Carhart. So it's important to bear in mind that intact D&E was a rare procedure then, and it's a rare procedure now. In fact, second trimester abortions in general are rare procedures. The CDC's latest stats show that date from 2018. And in that year, more than 75% of abortions were performed at or earlier than 9 weeks gestation. So very, very early. More than 92% were performed in the first trimester, earlier than 13 weeks. And those proportions were really about the same in 2004. Less than 10% of abortions were performed after the first trimester. But even though there were relatively few women who would be affected by Carhart and its ban, upholding the ban on intact DNA, as a practical matter, really, we have to say that the loss was significant. It was really significant for how the court stepped back and in its majority opinion, really embraced a view of women as less than, really a view from a much earlier time. The quote here is from Linda Hirschman's excellent 2015 book called Sisters in Law, about the jurisprudence of both Sandra Day O'Connor and Ruth Bader Ginsburg and their relationship on the court. Linda Hirschman is an Ohioan, a Clevelander, and I urge everyone who's interested in reading about these two icons to pick up that book, Sisters in Law. So the dissent starts out by looking back and spotlighting the court's 1992 landmark decision in Planned Parenthood v. Casey, which really became the defining case for the future of abortion jurisprudence. The majority in Casey expressly meant to dispel doubt about the meaning and the reach of Roe v. Wade, which had been decided, of course, 2 decades before. And Casey articulated the well-known undue burden standard. Even though a very divided court in Casey upheld parts of the Pennsylvania statute that was being challenged there, the opinion also affirmed several very important precepts. The right to choose before fetal viability, the undue burden standard, acknowledging that the state could restrict abortion after viability if it had exceptions for pregnancies that endangered a mother's life or health. Justice Ginsburg pointed out in her Carhart dissent the fact that the court was disregarding its own precedent in Casey and therefore was really abandoning its prior rulings that had consistently barred abortion restrictions that failed to have any exception for safeguarding a woman's health. And Justice Ginsburg was really clear about what the stakes were. It wasn't some general privacy right. It was really the core value of personal autonomy. It was the ability of a woman to exercise self-determination. And without that ability, Ginsburg viewed it as impossible for women to ever be fully equal citizens. She wrote, "Legal challenges to undue restrictions on abortion procedures don't seek to vindicate this generalized notion of privacy. Rather, they center on a woman's autonomy to determine her life's course." And this was not a new point for her in the slightest. This was a point she had been making through her work as an advocate, and at least since her Supreme Court confirmation hearing in 1993. As part of those hearings, she said, "The decision whether or not to bear a child is central to a woman's life, to her well-being and dignity. When government controls that decision for her, she's being treated as less than a fully adult human, responsible for her own choice." The central part of Ginsburg's dissent in Carhart is an attack on what she called the flimsy and transparent justifications for a nationwide ban on intact DNA without any health exception. The majority concluded that Congress could regulate this specific kind of abortion by citing ethical and moral concerns, but to allow those concerns to override fundamental rights for all women Ginsburg said, goes against settled precedent. And most telling for her was this anti-abortion shibboleth that the majority invoked. And what they were really saying is that women who have abortions come to regret their choices, and therefore they should not have choice. She didn't hesitate to call out Justice Kennedy, who was writing for the majority. For Justice Kennedy, all women's roles pale beside their role as mothers. And indeed, all of human behavior, he wrote, is the expression of respect for human life, which, he said, finds an ultimate expression in the bond of love the mother has for her child. Justice Ginsburg was really irritated by this formulation, and here's their kind of point-counterpoint debate in the opinion. She said, this is really a throwback to these ancient notions about women's restricted place in the family and under the Constitution, and these ideas have long since been discredited. And she felt, and the record bore it out, that there was really no evidence for Justice Kennedy's concept about how all women feel. He himself admitted it. He wrote, "We find no reliable data to measure this phenomenon about the regret that women feel for abortions, but it seems unexceptionable." So we get this conversation between Justice Kennedy and Justice Ginsburg, the authors of the majority opinion and the dissent, really battling it out. Next. Justice Ginsburg's dissent also noted the economic disparity, the economic issue that might really lead to a second trimester abortion, namely research that was in the record in the trial courts that showed that indigent women were the ones who were more likely to have difficulty obtaining an abortion during the first trimester of pregnancy. And this was a disparity that has only really gotten bigger, and a disparity, the economic burdens that could lead to a second trimester abortion that was still on Justice Ginsburg's mind a decade later. I want to play about a 3-minute clip of an interview that she gave in 2017.
You spent much time focused on the importance of reproductive rights for women. You've also written that the law is something like a pendulum. Are you concerned that maybe in some respects the pendulum could be actually swinging backwards when you think, for example, of the restrictions on women's ability, for example, to access abortions in many states now, where it's almost impossible in many states. They have to travel, they can't afford to. Or are you concerned about possibly the law actually moving backwards in some of the things that you fought so hard for?
Yes, but not for women like me, or most of you. And not because I'm well past childbearing age, but because if truth be told, there is no woman of means in the United States who will not be able to get a safe abortion if she wants one. All of the restrictions that we see in states like Texas operate only against poor women. In the Texas case we had a couple of years ago, it was obvious that the clinic in Dallas would stay in Houston, but the people who were far from the big cities and couldn't afford to take a day off from work, the restrictive abortion laws operate against poor women, and that's the sad story. We will never go back to the way it was before Roe v. Wade because there are a number of states. At the time of Roe v. Wade, there were 4 states that provided abortion in the first trimester, no questions asked. Alaska, Hawaii, New York, California, those states will not go back to the way it was. So it is a sad reality that any attempt to restrict abortion is going to affect only the poorest segment of the population.
And now there are even suggestions that perhaps Medicaid funding for even contraception could be restricted. Could you imagine that theoretically as an equal protection problem if contraception itself was precluded under Medicaid?
I had always thought that Roe v. Wade was put under the wrong heading. It should not have been due process. It should have been equal protection, the woman's right to choose for herself, to determine her life's course, her own destiny.
Prescient words. I'll close and turn it over to Laura with this quote from an ACLU assessment by Louise Melling, who wrote about RBG's jurisprudence shortly after the justice died last year. She said, with these words, she taught us how to lead even when we can't win. I dissent. And this may be our watchword as the fight for reproductive rights may be shifting from the high court back to the states. And with that, I'll turn it over to my co-panelist, Laura Hauser.
Thank you, Karen. Good afternoon, everyone. Karen kind of gave us some historical overview, and I'm going to jump in and start talking about reproductive justice from a little different angle and take us all the way through at least the end of 2020, and we'll talk a little about what's going on here today. Let's go to the next slide, please. All right, so I want to talk first about this case, Burwell versus Hobby Lobby stores. And I promise you that this is, I'm going to use a little more legalese and jargon about this case and not the others, just because the context and background of this case is really important. So I don't know how many people are familiar with these Hobby Lobby stores, but it's owned by the Green family. And it's a national arts and crafts chain. It has over 500 stores and 13,000 employees across the country. The Green family has organized the business around the principles of the Christian faith and has explicitly expressed a desire to run the company according to biblical precepts, one of which is the belief that the use of contraception is immoral and it's akin to abortion. Under the 2010 Patient Protection and Affordable Care Act, Obamacare, employment-based group healthcare plans are required to provide certain types of preventive care, such as FDA-approved contraceptive methods. And although there are exemptions under the ACA for religious employers and nonprofit religious institutions, there are no exemptions available for for-profit institutions like Hobby Lobby. And Hobby Lobby is a privately held company. It's not a public company. In 2012, the Greens, as representatives of Hobby Lobby, they sued the Secretary of the Department of Health and Human Services and challenged the contraceptive requirement of that law. The plaintiffs argued that that requirement violated the free exercise clause of the First Amendment and the 1993 Religious Freedom Restoration Act. We're going to call it RFRA. The procedural of the history of the case is kind of sticky. It went up and down from different courts. But the case that was ultimately presented to the United States Supreme Court had one principal question, and that is, based on the religious objections of the company's owners, does the Religious Freedom Restoration Act of 1993 allow a for-profit company to deny its employees health coverage of contraception to which the employees would otherwise be entitled? Let's go to the next slide. So in a 5-4 decision, the Supreme Court said, yes, they can deny contraceptive coverage to its employees. And again, we're hearing from Justice Samuel Alito, and he delivered the opinion for the 5-4 majority. And the court held that Congress intended for RFRA to be read as applying to corporations since, and you'll hear this concept in other lines of court decisions, corporations are composed of individuals who use them to achieve desired ends. And because the contraception requirement forces religious corporations to fund what the Greens considered to be abortion, which goes against their stated religious principles or face fines, it creates what the court called a substantial burden that is not the least restrictive method of satisfying the government's interests. Justice Kennedy wrote, and you just heard from Kieran about his perception on certain things. He wrote a concurring opinion with a slightly different interpretation, but he reached the same outcome by merging together the concept of a nonprofit religious organization to a for-profit corporation under the Supreme Court's interpretation that corporations are just like people. They're more like individuals. Let's go to the next slide, please. I like this quote from the New York Times because it helps us distill what the majority did. If you take this case away from the very heated concept of reproductive justice and you look at it from a different lens, the court seemingly honored the corporation's wishes as if it were an individual, rather than a for-profit entity that's leveraged from its employees and customers, not all of whom share the Greens' anti-contraceptive beliefs. Let's go to the next slide. Justice Ginsburg wrote a 35-page dissent, and on this slide is perhaps the most impactful quote from her dissent. And there's so much literature about this, and much of the commentary has been devoted to this concept of what could be held a sincerely, or what could be labeled a sincerely held religious belief, particularly since this seemed to have such a subjective element to it. Let's go to the next slide. Here's some of the analysis from the dissent that has been most often quoted. This thought that the exemption would deny legions of women who do not hold their employers' beliefs access to contraceptive coverage. What's implicit in that is that you probably only should be working for employees who have the same religious belief as yours. And that seems to be quite antithetical to people's working relationships within and without or and outside of their own communities. Let's go to the next slide. So this is one of Justice Ginsburg, her other highly quoted cite from this opinion. And I'm going to go through some of the things that she said and talk a little bit about what's actually happened since then. And what she says is approving some religious claims while deeming others unworthy of accommodation could be perceived as favoring one religion over another, the very risk the Constitution's Establishment Clause was designed to preclude. And she says, in the opinion, would the exemption extend to employers with religiously grounded objections to blood transfusions, who are Jehovah's Witnesses, antidepressants, Scientologists, medications derived from pigs, including anesthesia, intravenous fluids, and pills coated with gelatin? Those are issues held by certain Muslims, Jews, and Hindus, and vaccinations. And what she said is, by raising these questions, this opinion provides not much help there for the lower courts bound by today's decision. Let's go to the next slide. So the aftermath of this, I say it's divergent. There's a couple things that happen, all of which is pretty dramatic. First of all, the Obama administration quickly swept in to close the loophole that the Supreme Court created in the Hobby Lobby birth control case. In response to the decision, the Obama administration extended the birth control accommodation that was originally provided only to religiously affiliated nonprofits. In particular, the accommodation was extended to closely held for-profit entities, such as Hobby Lobby. However, although Hobby Lobby-like companies can refuse to cover birth control in their health plans, the loophole that was closed required health insurance companies to directly provide birth control at no cost to employees. What I could not find is whether this closing the loophole was truly effective, in that if depending on whether the corporation chose certain healthcare plans or not, if they were privately managed healthcare plans internally. And this headline here that you see, this is a headline from a slate.com July 8, 2020 article, which is, again, this quote is something picking up on the themes that Karen was talking about. This court's latest ruling is part of a web of decisions that demote women to bystanders. And in the picture that you saw earlier in one of Karen's slides with President Bush signing a piece of legislation, you notice they are declaring the rights of women, but everybody participating were men, which is interesting. So what happens next, I have these two cases. We're going to talk about Little Sisters of the Poor. So there's the Wheaton College and Little Sisters of the Poor case, and I'm going to talk about that in a minute. But there was a lot of discussion, and pundits issued a lot of commentary about following up on Justice Ginsburg's pondering whether any type of semi-organized, organized religion could claim that they have a sincerely held belief to exempt themselves from the law, and that it might open a floodgate of exemptions to this. And more recent literature talks about the fact that that never really happened, not on any large scale. But Wheaton College and Little Sisters of the Poor are pretty interesting. So the Supreme Court had suggested that the implications of Hobby Lobby were actually broader than what Alito described when he wrote the opinion. And just days after the Hobby Lobby opinion, the court's majority allowed Wheaton College, which is also religiously oriented, to refuse to fill out a form asking for an exemption from the Affordable Care Act birth control mandate. And then there's the other case, Little Sisters of the Poor. It's the same issue. And in that case, a religious order asserts that filling out the exemption form, which if granted would exempt them from the law's requirements, they claim that that violated their rights. If just filling out a form can count as a substantial burden, it's hard to imagine any obligation that would not. So just about any sincerely held belief under Alito's interpretation and others in this next case would exempt those folks from providing those services to women. Let's go to the next slide. So in Little Sisters of the Poor, the Supreme Court upheld a Trump administration rule that greatly broadens a religious exemption to the contraception mandate of the Affordable Care Act. The holding of this case is that the Departments of Health and Human Services, Labor, and Treasury had authority under the Affordable Care Act to promulgate rules exempting employers with religious or moral objections from providing contraceptive coverage to their employees. The judgment reversed and remanded a lower court's decision. There was a 7-2 opinion authored by Justice Thomas, and it was issued, as you can see here, July 8, 2020. And that date is important. We're going to talk about that. It held that the Health Resources and Services Administration had the power to create contraception coverage exemptions. Justices Alito and Gorsuch, there's Alito again, he keeps popping up. He filed a concurring opinion in which they explained that the First Amendment protections of the Constitution allowed exemptions to the Affordable Care Act for sincerely held religious beliefs. Under the Little Sisters of the Poor versus Pennsylvania decision, an employer with a sincerely held religious or moral objection may now decline to cover their employees' contraception care. The government estimated during the oral arguments that broadening the religious exemption would result in as many as 125,000 women losing what was then, or up until then, their statutorily mandated contraceptive coverage. The sisters, sounds like there's some nuns in a convent tucked away. This opinion did not observe, nor was it important to them, that the Little Sisters are a multi-state organization with 30 residences and hundreds of lay employees throughout. Let's go to the next slide. And you may remember, and this is a quote from Justice Ginsburg's dissent, joined by Justice Sotomayor. And Justice Ginsburg participated in oral argument on this case from her hospital bed. This is, one of her later decisions, later dissents. And as the dissent notes, the animating idea behind religious accommodations is that the government may surely accommodate religion, but it may not benefit religious adherents at the expense of the rights of third parties. That was what she was promoting in her dissent. And the third parties here are women who simply have fallen out of the majority's calculations. Another instance where women are becoming bystanders. And keep in mind that this decision was issued during the pandemic, when women were more burdened by childcare and other stressors, and perhaps more in need of access to contraception at a time when their economic status and prospects were being greatly challenged. Let's go to the next slide. This is a quote from the Hobby Lobby case. And Little Sisters of the Poor really transcends from that. There was an article I read. I'm going to read a quote from it. It distills all of this together in an interesting way, and it forecasts where we might be going next. And what this author said was that if President Biden rescinds the Trump exemptions, religious employers will likely push to revisit the question left open by Little Sisters of the Poor by suing on the grounds that broad exemptions are required by RFRA, the statute we talked about earlier. When that occurs, the strongest counterargument will be that the exclusion of contraceptive coverage from otherwise comprehensive employer-sponsored insurance plans constitutes impermissible sex discrimination under Title VII, and that the government has a compelling interest in preventing such discrimination. Furthermore, a finding of Title VII discrimination can, in the words of Justice Alito, exert a gravitational pull in constitutional cases. Interesting that they pulled his quote into that concept. The author also said a government-created or court-mandated exemption scheme that allows employers to discriminate, thus implicates serious equal protection concerns. And I like this quote because it ties back into what Justice Ginsburg was speaking of in the clip that Karen showed in the video too, pulling that back in. This is not a due process case, it's the equal protection case. Let's go to the next slide. So the cases that we talked about today are about access to contraception and abortion care. And I put this slide up, it's a bit dramatic, but as we are all witnessing women's access to abortion and contraceptive care, both through insurance and another means, be increasingly more restricted. Where is this leading our women who are of a reproductive age? Justice Ginsburg clearly fought to maintain that access. She talked about it during her testimony, during her nomination process, during her investiture. She gave a speech talking about access to reproductive care and reproductive justice. And I believe that we need to fight in her spirit and be vigilant to protect what is clearly becoming diminished access to reproductive justice and rights for women. Karen, any thoughts?
Yeah, definitely. I think it's a scary time. You referenced women of reproductive age, but of course, every woman of reproductive age is a daughter, a granddaughter, a niece. And so, I, as a baby boomer, have lived experience of what it was like, before Roe v. Wade, and the thought that we might be going back there on a federal level is chilling, just chilling.
Well, at this point, I'm going to hop back on screen and rejoin the conversation. Laura, Karen, thank you so much for your presentation. That was really interesting, really informative, and a little, frustrating at times to just hear the way that these rights are being eroded. But at this point, I'd like to invite anybody in the audience. If you have any questions or any comments for Laura, for Karen, you can send them in through the Q&A in the bottom left of your screen, the bottom left of center, or in the chat. So first of all, the first question I had for the two of you, Karen and Laura, that I wanted to dig into is about this idea of sincerely held religious beliefs that you were just talking about. And so this is kind of a hypothetical question, but if we were to turn the tables and ask about a sincerely held moral obligation to save the life of a pregnant person, do you think that that would hold water under the terms of this argument that we just heard outlined, in either in Alito's perspective or from the perspective of anybody on the court who would have heard that?
Karen, start with Carhart. I think the answer is no.
Right. I think under Carhart, no. No, I can't see that there would be any right, or any moral basis for coming out that way under that case or that line. What do you think?
I think they took a hard line in that case and ignored that principle. So I think based on what I know about most states' laws, they're the cases in Texas and Oklahoma, or excuse me, Mississippi and Texas, forgive me if I misquote, but that have found certain laws to be unconstitutional because of that and struck them down, although, what's going up to the Supreme Court now could turn all of that on its head. So hard to say.
Okay. It's an interesting answer. And so I do want to talk a little bit about what's going on with the Supreme Court today in a couple of minutes. But before that, I wanted to circle back to Carhart and Gonzales really quickly. And so that case is different than the other ones that we've been talking about today. And you touched on that a little bit just now briefly. But there is this big difference in focus from medical viability of the fetus versus religious freedom of those who oppose abortion. And so in these two cases, I'm wondering, could you talk a little bit for the audience about how the differences in focus or in tactic might have impacted the majority opinion or dissent in these two cases?
So yeah, it's very interesting. That's a great question. The fact that the lens that we're looking at Carhart through is a medical one, and all of the huge amount of evidence, because as these cases go up, first starting out in the legislative arena with congressional hearings that develop an enormous body of or they tried to develop an enormous body of evidence looking for that medical consensus, for instance, which was nowhere to be found. And then as the parties developed their arguments in the district court, there was evidence presented to district courts, two different ones in the two different cases that were eventually consolidated. So all of this evidence is essentially medical evidence. What is intact D&E? What does it consist of? How many women use it? Until we get to Justice Kennedy's formulation about what he feels that women must feel, without any evidence about to sustain his intuition, to buttress what he enshrined as a constitutional principle without that evidence. And so then we turn away from the medical realm, and we get this, we go to the realm of religious freedom. And so there's really kind of two different lenses that we're looking at this through. I think what the force of RBG's dissents shows is that in some senses, the results for women are the restriction of access to on the one hand, is the same, a restriction of access to contraceptive care and a restriction of access to a procedure that could be needed without any exception for the health of the mother, and an exception that uniquely burdens poor women. So, you know, you get two different lenses, but you get the same kind of trammeling of rights that we thought we had guaranteed.
Thank you. Laura, do you have anything that you would like to weigh in regards to this question?
I think if that case went up to the Supreme Court today, not that the outcome would be any different based on the composition of the court, but the evidence would be a little different, because since that opinion, the Guttmacher Institute has done a number of studies about women and abortion care. And I can't remember the exact statistics, but virtually all women do not regret their abortion decisions. And implicit in that is what Justice Ginsburg spoke about often, in that women are capable and competent of making their own decisions about when and how to have children. And you need to trust women and the decisions that they make with their physicians. So, you know, Kennedy's basis is fiction, and it's some fantasy that he had to justify his position.
Okay, thank you. I appreciate you both taking the time to dig into that question, even though we talked about both of those cases already earlier in today's program. And so now I would actually like to talk about something that we haven't talked about at all in today's program, but Laura, your answer led me to a little bit, which is the court of today, today's Supreme Court. And so this week, actually, very topical, very timely, the Supreme Court announced they would be hearing the case Dobbs versus Jackson Women's Health Organization. And this is going to be the very first time that the court has considered a state restriction on abortion since Justice Amy Coney Barrett was confirmed last fall. And so for the two of you, in your opinions, based on just everything you know of today's court, everything that you know of the history of the way that we have legislated and done jurisdiction around reproductive rights in this country, what do you think that we can expect to see from today's court going forward in this case or similar cases?
Well, I'll take this. I'm sure Karen will come at it from a different angle, but it's hard to say. What they're trying to do is restrict abortion access past 15 weeks. And I have not read the underlying, the lower court's decision, so it's certainly not a viability issue. But it's hard to predict what the court is going to do. I think Amy Coney Barrett is clearly on one end of the spectrum. What's uncertain is, you know, where are Roberts and Kavanaugh, because they've both, Roberts in prior decisions and Kavanaugh during his nomination hearings have both expressed deep institutional respect for precedent. And they may come at it from that perspective, but that leaves only 4 people or 4 justices who may find this law to be unconstitutional. And still there could be a 5-4 majority, even with Roberts and Kavanaugh finding it to be unconstitutional. So hard to say. Amy Coney Barrett is clearly on one end. I would just make that assumption. Maybe I could be wrong, but you know, until and unless they either change the composition of the court or the Biden administration does something to shake things up with executive orders, I think abortion rights are greatly threatened. Karen?
Agree. Agree. I think we have to assume that Barrett is a staunch vote. She'd like to overturn Roe v. Wade. I also haven't seen I haven't read the lower court decision, but I do agree that Roberts and Kavanaugh are going to be key. Will they adhere to their announced respect for jurisprudential precedent? This is what our system depends on. The reasoned adherence to what has gone before. or are they going to throw that over? It's not apropos to say the jury is out, but that's that's the comment. That's kind of the comment we're going to have to wait and see. What is certain is that if Roe v. Wade falls, we are going to see a new era in which the federal constitutional right to seek abortion is thwarted or found not to. It will be overturned, and that will put it back down at the state level, where it was 50 years ago, and that really opens up the question of what are we doing on the state level to perhaps prepare ourselves for the eventuality that we're going to be in that situation, that's an ongoing question, I think.
It brings to mind for me from the video you shared earlier with Ruth Bader Ginsburg, the comment about the pendulum swinging, that this feels like we might be in a moment where the pendulum, we're seeing it swing again, but that it's not without hope that it will swing back. And so on that note, go ahead. Sorry. I'm so sorry, Laura.
Oh, that's right. With this case that's before the Supreme Court now, I mean, what you have to keep in mind in terms of the jurisprudence too, is that Roe v. Wade was decided primarily on the basis that abortion rights and care fit within a person's constitutional protected right of privacy. And the conservatives on the court forever have been challenging that it doesn't explicitly say in the Constitution that was issued more than 200 years ago that abortion care is a protected constitutional right of privacy. So if they're going to uphold this law, my prediction is going to be that these folks are going to abandon precedent and overturn on that issue, but we'll see.
Karen, do you have any thoughts on that?
Agree with Laura.
Well, I, for one, will be curious to see how things go, and I'm hoping for the best. On that note, which I think is probably the most optimistic way that we could wrap up this conversation, I would like to thank you both, Laura and Karen, for being here with us today. On behalf of the Maltz Museum and the Cleveland Metropolitan Bar Association, thank you for your time with this presentation, and thank you for everybody who joined us from home. It was wonderful having you with us today. If you enjoyed today's program, we have two programs coming up that might be of interest to you. First, on June 16th, we'll be having the final program in the Dissent series, a discussion on affirmative action with Judge Michelle D. Early, Carol Rendon, and Marissa Darden. And in July, we will be having another program on reproductive rights and RBG's involvement with them, with a virtual gallery talk on the Women's Rights Project with the ACLU's Sabrina Harris. And that will be on Wednesday, July 7th at 4:00. Both of those events and so much more can be found on our website, www.maltzmuseum.org, coming soon as we hurry to bring you our final summer calendar. With all that being said, thank you again for joining us today. Laura and Karen, thank you again for a wonderful presentation. And on behalf of the Maltz Museum, have a great evening, everybody. Thank you.